got it. A single member LLC is disregarded for tax purposes. So you can do it. You can use it to do a 1031 and not blow the exchange. So that's probably why they permitted it to be, not for, because although that would be income producing, but someone buys a home in Atherton, puts it in an LLC so that, they don't know that Steph Curry, the registered owner of the mansion is not Steph Curry, but, household something LLC.
But wasn't there a reg passed that you have to report who the real owner is to the IRS?
That's the new Corporate Transparency Act, which could be a whole session in itself that will be effective later this year, next year, and that will require everyone to fill a form that identifies the owner of an LLC unless it's exempt. To the FinCEN, the Department of Treasury's Financial Crimes Network, which is supposed to be confidential, if you believe that.
Mm-hmm.
Okay, we're after 5. I see Hillary. Hi, Hillary. You got to pay careful attention. Can't be on your iPhone.
What?
Yeah, sorry. That's one of the rules to get credit. We'll have one of these things where you have to push a button.
To make sure like you're still out. Yeah, you're
Yeah,
still
you say,
awake.
yeah, I'm in the room.
Isn't one of the other rules is that all the attendees have to pay us each a $1,000 stipend?
Oh, there you go. Whoops, you watch that. That'll all of a sudden have 10 people leaving the meeting.
I think we're running on Greek time, so let's give these people another few minutes, because I think there's 5 more people at least that are going to get on.
Hillary, you have time to say hi to your dad.
Is he here?
Yes.
No, I didn't see him on the. Hello. Oh, there he is. Hi.
I don't see.
Oh,
There he is. Hi, Frank. And it looks like we got Jason Bezos and Angelina Saras. You guys are hiding out without your picture or your video. There's Jason.
Here's Jason.
hello.
Hi, Angelina.
Hello.
Hi. Hope everyone had a nice Easter.
Christos Aneste.
Oh,
Yeah,
yeah, Lithos Anesti.
Okay, I think we've got enough people here. I'm going to start the meeting, and our webmaster Stuart can leave. Kalinikta Stuart.
You want me to leave? Okay.
So tonight's talk is choice of entity, and it's an MCLE event. You should have gotten a couple emails, one with materials from each speaker, and one with your 3 MCLE items. If you want credit, you have to sign the acknowledgement with your state bar number and email it back to me or Stuart. You also have a copy that you keep for your own records of a separate certificate, and then you can fill out a evaluation form. So if you don't have those, you can send me an email and I'll forward them again. But if you don't fill that stuff out and the state bar audits, you might get in trouble because you're supposed to give us a sign up. So with that, I'm going to introduce our speakers. Many of you know our longtime members. Jim Fatinas has been practicing corporate law for many, many years, many decades. He's written a book with the Rudder Group on corporations. He'll be doing for-profit corporations, how to set them up and the like. And our second speaker is our another longtime member, one of the founders of the organization. And he likes to claim he's the only board member who's continuously been on the board. Peter Bagatellis, he has a practice in political law and nonprofit law, and he'll be talking to us about nonprofit corporations. Jim, take it away.
Okay, thanks, folks. So we have a lot to cover. I'll move quickly. As Peter mentioned, yes, I'll be talking about for-profit entities, not just corporations. And this presentation is a very abbreviated summary of actually 2 chapters in the 2 Rudder guides that I have authored or co-authored, although I retired from active authorship last year, and of course they'll go downhill from here. But they've still got my name on the spine: the Rudder Guide to Corporations and the Rudder Guide to Pass-Through Entities. So here are the types of entities. Can you all see the slide presentation?
Yes.
Okay, so here are the options. Sole proprietorship, this is when our papus or great papus or great papus came over from Greece, opened a cafe. Single person, it's a sole proprietorship, just an individual. It's actually not an entity, but that's, the most basic form of business. General partnership, if Papu had a brother and there are 2 of them, then they would have been a general partnership. You don't need a written agreement to be a general partnership. That's 2 or more persons forming or gathering together to run a business. A limited liability partnership is a species of general partnership. It's in California available only to professionals like lawyers, accountants, architects, land surveyors, and engineers. It's not available to doctors. For some reason, the doctors politically just never get their act together. So anyway, that's an LLP, virtually the universal form now for law firms and architectural firms. Limited partnership, that's sort of the granddaddy of the investor type entity. You have at least 1 general partner and 1 limited partner. Used to be very popular, now not so popular, although it's used a lot in the fund business, private equity funds, venture capital funds, just for historical reasons. Here's the most popular now pass-through entity, LLC, limited liability company, been available since 1994. It's sort of the entity of choice if you're going to form like, a single asset entity, like buy a apartment building or activities like that. And again, the benefit is it's pass-through taxation, meaning it's only 1 level of tax and it's limited liability for the members. And finally, the corporation, which is still obviously extremely popular. And if you're going to form an entity for a client who is, high tech, biotech, whatever, they're going to be, unicorn billionaires within 5 years, you'll form it as a corporation, probably a Delaware corporation. So this is data from the California Secretary of State, shows filings of the various forms of entities, 2010, 2015, 2020. So for 2020, let's see, look at the popularity of LLCs, 190,000, and that was the year of the pandemic. So imagine these are the most recent data I have. I'm sure it's a lot higher now. You can see LLPs, see they're not used nearly as much now as LLCs. LLPs, as you would expect, if they're only available to lawyers, architects, etc., not many are formed. Then corps, see 103,000. still a popular form of entity. For comparison's sake, in Delaware for the year 2019, the most recent year that I have available, you'd think, with all the press that Delaware gets, it would its number of filings would dwarf California's. That's wrong. Delaware in 2019, 45,000 corporations were formed compared to 103,000 for California. And Delaware LLCs, 165,000 were formed. Still a lot less than 190. So California continues to be a dominant state for the formation of entities. Clearly, the amount of capital invested in Delaware entities dwarfs that of California, just because all the public companies and all the startups incorporate in Delaware. We could have a separate webinar just on the reasons why. Okay, so sole proprietorship here, the character. Go ahead, question. Someone have a question? Okay. So again, sole proprietorship, just simple. It's, you don't need to do anything, file anything with Secretary of State. You just open the doors, get maybe your business license from San Francisco or the county, and away you go. It's unlimited liability for losses. So someone gets hurt and sues you, you can't avoid, everything you own is at risk. You can't have employees. If you have employees, you'd have to get a, employer ID number, et cetera. And you should file a fictitious business names statement if you don't operate using your last name. General partnership, again, 2 or more owners. If you engage in business for profit, there's no formalities, although certainly if they come to you, it's foolish not to have a written partnership agreement for obvious reasons. Used to be a partnership. General partnership was considered an aggregate of its partners, but now it's by statute considered an entity separate and apart from its partners, so can sue and be sued in its own name, although there are tricky aspects about whether you would, certainly when suing a general partnership, whether you name all the partners. That's a separate topic. And then here's some other, the profits are shared equally unless you agree to the contrary. And here's the big negative for general partnerships. Each partner is jointly and severally liable for all debts. That means if you have a general partnership of 100 partners, even if you had nothing to do with, partner 60, who engage in conduct that subjects the partnership to a $10 million judgment, each partner is jointly and severally liable to pay that debt, including with all your assets, even outside the partnership. That's why the form of general partnership is disfavored, and you should strongly recommend to anyone who wants to form one that they should do so. Or if they do so, each partner should be an entity in itself. So in effect, this used to be the routine in law firms before LLPs were authorized in the late 90s. So you'd have John Doe PC, professional corporation, as a partner of the, Doe and Moe law firm. Believe it or not, there's still some major law firms that are general partnerships. Jones Day, a major law firm, is a general partnership. Don't ask me why. Each general partner has equal rights to run the show. Partners have fiduciary duties to one another. Apologies, this citation is wrong. It's 16-404. Haste makes way. So the statute that imposes fiduciary duties on each partner is 16-404. And then we talk about, there's some other characteristics that I give you the citations. This is a fancy word. It used to be if you resigned from a partnership, you just, if you resigned from a general partnership in the old days, it dissolved the partnership. No longer true. If you withdraw from a partnership, it's now called disassociation. It's a fancy term. I don't like it, but that's what it is. And you're supposed to be bought out, but the provisions are complicated. And if the general partners, for example, agree to have a term of 10 years and you withdraw year 1, yes, you're entitled to be bought out, but you're subject to damages for leaving early. And even if you're entitled to some money, you won't get paid until the 10 years are up. So a limited partnership. These are, you have to have at least two partners, one general partner and one limited partner. Can't be the same person, but they can be, you know, Peter Bagatellis is the general partner and Peter Bagatellis, the trustee, well, Peter and Ann as trustees of their revocable trust as a limited partner. That'll work. You have to, unlike the general partnership, no filing is necessary, but general partnerships can file a optional statement of partnership with the Secretary of State. Sometimes general partnerships do that, so they can then record the statement of partnership in the county where they own real estate to facilitate transfers. So a limited partnership, you have to have one GP, one LP. You file it by filing a certificate of limited partnership on Form LP1 with the Secretary of State. Simple form, one page. You can get it off the website. And now you can file. With the advent of BizFile about a week ago, it's been a complete disaster. Any of you who've had to deal with the Secretary of State in the last month know what I'm talking about. It's a disaster. You file things and you find out 3 weeks later whether it's been accepted or not. Just ridiculous. But hopefully, when their new system is up and running, it'll be a lot more efficient. You can file your LP1 and same day get confirmation you formed your limited partnership. And then you need a limited partnership agreement. It can be oral, but obviously it should be written. There are forms of limited partnership agreements in the Rudder Guide to pass through entities. They're pretty decent. So if you get the Rudder Guide, you can get a form, simple form. Well, it's not that simple, but it's a form of limited partnership. The general partner has the same liability in a limited partnership as in a general partnership. Most GPs, if they come to you for advice, will be an entity itself. So no longer would Peter Bagatellis be the general partner of a limited partnership. It'd be Peter Bagatellis LLC. So that even the GP is not, totally at risk. Sort of the name of the game. And then the idea is the LPs are passive investors. They don't take part in running the business. That's a limited partnership. And here's more information on limited partnerships. The statute sets forth a bunch of default rules that apply even if you don't provide for it in your partnership agreement or don't have a partnership agreement. So for you share profits, losses, and distributions in proportion to the partner's contributions. So if each partner puts in, equal amount of money, they share equally. That's usually not the case. So usually a partnership agreement will not necessarily allocate distributions or profits and losses in accordance with contributions. There may be some special allocations, but that you can all lay out in the partnership agreements. Generally, interests in LPs are not freely assignable, but you can assign, subject to provisions in the partnership agreement, your right to distributions. That's called the economic or transferable rights, but you can't assign voting rights or information rights. Used to be that the death or withdrawal, as I said earlier, dissolves a partnership. No longer, the death, withdrawal, or incompetence, you name it, of a limited partner does not dissolve the limited partnership. But these events that involve the general partner does dissolve the partnership unless the limited elect a successor. This is the LLPs. This is what you would do if a lawyer, accountant comes to you and says, we want to form a practice. You form as an LLP. Same thing, you file a one-page document with the Secretary of State, but then you also have to file and register the LLP with the relevant regulatory authority. In the case of lawyers, it's the state bar has a LLP division. So you file forms with them before you can practice as an LLP, and the forms are addressed and included in the Rudder Guide. And you got to carry so the individual partners of an LLP are not jointly and severally liable for the partnership's debts. the LLP swept the nation late 90s. You may recall Arthur Anderson was bankrupted by represented a client, I forget, a Texas high flyer, and the federal government sued them. I think indicted them. Arthur Anderson, you can imagine that. I mean, a general partnership, 3,000 partners or more, and bankrupt the firm, and that was probably, it was considered probably overreach, and all the state at the behest of the accountants passed LLP legislation. So if in an LLP, if you're in a 10 person partnership and one of your partners commits malpractice and you get stung for $100 million judgment and your insurance is exhausted, your personal assets are not liable for that judgment unless you participated in the misconduct. That's why now virtually all law firms and accounting firms are LLPs. You have to maintain the security for malpractice claims. Most people do that through insurance, and the maximum required amount, I think, is $7.5 million, depending on the number of partners. For smaller firms, it's like $1 million. So that's sort of the LLPs. And LLCs and LPs pay the $800 minimum franchise tax, one of the detriments. Although for this year and next, the first year of their existence, the 800 is waived. Yes, I say here. And then, of course, now the good news is LLPs and LLCs do not pay an entity tax. So that's why people do it as opposed to corporations like a PC. Okay, and then here's the entity of choice, as indicated. 190,000 of these were formed in 2020 alone. Again, it's the entity of choice. Again, it's formed through the filing of a one-page form of the Secretary of State. You need only one member. So unlike a partnership that has to have at least two members, two persons, you can have a single member LLC. And single member LLCs are very popular because they can be disregarded for tax purposes. That's technical, but it means if you have a single member LLC, you don't have to file a separate federal income tax return or state income tax return for the LLC, with one exception. I'll explain in a second. And so they're very popular for 1031s because being disregarded for tax purposes, if you own real estate as an individual, but exchange into, an apartment complex, you can do it through a single member LLC. The LLC is a separate entity. You have some protection, but it still works for 1031 purposes. So they're very popular in 1031 land. So again, a single member, separate legal entity, you file an LLC 1. There are two types of LLCs: manager managed and member managed. If you're small and each member will participate in the business, then it's member managed. If you're going to have one of the members or an outside person manage the LLC, then which does not have to be a member, then they're manager managed. For those who like anonymity, each of the entities I've talked about, except I think LPs, have to file a statement of information annually with the Secretary of State. If you're member managed, you have to identify each member, and that's public. You can go on a Secretary of State's website and get the filings for all LLCs, corporations, and LPs, not LLCs, not LLPs. If you're member managed, you just identify the managers. So if the members don't want their name and address splattered in a public record, that's one reason to do it member managed or manager managed. And then these are the default rules. Managers and a manager and a manager managed, and members in a member managed have fiduciary duties. They're set out in this section, 17704.09. You can modify the default rules by written operating agreement. The rules are very complex as to what you can modify and what you cannot. They're set out in this section, 17701.10E. They're very complex, so you really need to look at that if you're working on an operating agreement and the members want to have certain special rules. And then LLCs are not available for professionals generally. I mean, there is a Attorney General letter that allows people like cosmeticians and repairmen and barbers to form LLCs, but lawyers, architects, accountants, doctors cannot practice as LLCs. The poor doctors, since they're has such little clout in Sacramento, the only way a medical professional can insulate himself or herself is to form a PC, a professional corporation, which we won't talk about here. And then these are corporations, okay, been around forever. Again, you form a corporation by preparing and filing an articles of incorporation. It can be a simple one-page document, usually is. You can actually use the form that the Secretary of State provides you. Where it gets complicated is if you have more than one class of equity, like preferred stock, then it gets pretty complicated. So you need articles, you should have bylaws. Again, there are forms in the Rudder Guide to Corporations. One of the reasons people like corporations is the forms are pretty simple. Unlike general partnerships, LPs, LLCs, the relevant agreements, the partnership agreements and the LLC agreements are lengthy, complicated, and unless you've done a lot of them, a real pain to draft. That's why the forms in the Rudder Guide or elsewhere are often helpful. As you know, basic rule corporations are supervised, managed under or by or under the board of directors. And the duration. The big negative, of course, of corporations is two levels of tax at the corporate level, and then again, when the corporation turns around and pays dividends at the shareholder level. So that's why corporation generally, if people can avoid it, then they're not, high tech or whatever, don't like corporations. So you can elect S corporation status. That's a separate topic to avoid two levels of tax. And the flat rate now 21%. There's no pass through of losses. I forgot one thing. I said that the pass through entities don't pay entity tax. The LLCs do pay a fee, they call it, ranging from nothing for gross revenues of less than $250,000 to like $12,000 if their gross revenues of $5 million or more. It's graduated between those two levels. That's a special fee based on California sourced income. That's one reason a lot of people don't like LLCs in California, so they form them in Delaware. So that's sort of a lightning round of entity choice for for-profits. Any questions? I know it's a lot to absorb in 30 minutes or less.
Jim, how does the issuance of stock come into play, and how is that done and determined?
Okay, well, that's usually determined by how much money you need. So that's a good point, Peter. So if you're going to form I don't care what the entity is. The first question is, well, how are we going to fund the business? And usually, small companies fund it by people either contributing cash or sweat equity. And so the board or you authorize, if it's a corporation, the board authorizes, adopts, or resolutions, authorizes the issuance of stock. People get shares for paying for their stock. You then have to worry about filing a notice of exemption, because anytime you issue stock, you have to worry about securities laws. And usually, small companies, the issuance of stock is exempt from registration, thank goodness. But you do have to file a form or think about filing a form, depending on how much you raise and how many stockholders, with both the SEC and the state of California, and or in other states where the shareholders reside. That's covered in the rotor guides too.
Question about real estate holdings for LLCs. Now you talked about the 1031 as one vehicle for I guess for ownership for with the LLC, but what about say an alternative for like joint tenants? Let's just say there are a lot of Greek Americans who end up buying property, real property, and I have no idea whether it's say LLC makes sense in modern times as an alternative to joint tenancy, I guess, to for future generations. I know I'm thinking you've got the Prop 13 layer here in reassessment in California, so I have no idea how that would interact with LLCs. But I wonder if you could speak a little more broadly.
Yeah,
with
briefly.
LLCs.
Usually it's tenants in common. I don't know the joint tenancies work.
Yeah,
but
yeah, okay.
you have okay, so 5 colleagues have a tenancy in common interest, which is a direct interest in real estate in complex, and they want to sell it and they don't want to pay taxes, so they'll do an exchange. And yes, you can take the proceeds of the sale, and as long as you follow the 1031 rules, deposit it with an exchange agent, identify the property within 45 days, close within 180. It's not unusual for you to take title in the replacement property as an LLC. So if it's Jason, selling it personally, a TIC interest in his own name because he's had it for 10 years, and then he's advised, okay, yeah, put the proceeds in a replacement property, but instead of holding it in your personal name, hold it in a Jason LLC. That works for tax purposes because a single member LLC is disregarded for tax purposes. So it's considered an exchange of real estate for real estate, even though you now hold the replacement property through an LLC. And you're then insulated to some extent because it's now an entity owning the, new apartment rather than you personally. And if you observe the formalities, you should have some level of comfort or protection from a disaster. So that's, and a lot of times if you're borrowing money, lenders want you to be an LLC for a lot of reasons, including continuity, because for technical reasons. So yeah, LLCs are used a lot in the 1031 world to acquire replacement properties.
Jim, before we turn it over to Peter, because his time is going to start eroding, there's a lot of topics that you just barely mentioned. Are you available as a mentor to our younger members or our novice mentors? Even though you're at a gigantic law firm, do you ever work with novice lawyers or younger lawyers and help them?
Yes, well, yes, I do. I'm so old that I spend time on pro bono because this firm I'm of counsel now, so doesn't mean I have more time. But yeah, I'm always happy to talk to certainly members of our society. It's my pleasure to do that.
Okay, well, maybe we'll have more questions at the end. I want to get Peter Bagatella started on nonprofits and what you do to get those going. Peter.
Sure, thank you. Well, given the short period of time that we have, can't expect more than a primer on nonprofits here. So we're not going into a lot of depth, but it's basically a how-to to set up a nonprofit. Unlike the profit entities that Jim talked about, the people involved with creating and running a nonprofit do not have the ability to own the income or assets of the organization or to have a proprietary interest in them. As a matter of fact, under the IRS rules, you generally have to watch out for private enormement. That's the catchphrase, where people are unjustly enriched by their involvement with a nonprofit, and it poses different fine and penalty and loss of exemption repercussions if you get into that area. When I get a new client that wants to set up a nonprofit, I usually start by explaining to them that there's two basic foundational aspects you have to look at. One is the legal form of the entity, and the other is its tax status. Because a lot of people get all confused and they keep referring to an entity as the C4, which is a tax status, as if it's an entity. And I usually have to go through an education process with folks and get them to understand that, as well as the difference between directors and officers. They get all confused about what the role is of each. Directors generally are the policy-making people that run an entity and control it, have all the powers of the entity. The officers are the arms and legs of the organization that carry out the programs and policies set by the directors, and usually includes like a president, vice president, secretary, treasurer, executive director among the officers class. So what are the legal forms of an entity? Jim just went through a whole bunch for the on the profit side. On the nonprofit side, there are generally three that really come into play: a corporation, an unincorporated association, and a trust. I think there is some opportunity for an LLC perhaps to qualify as well, but generally I don't deal with LLCs in the nonprofit world. On the tax status side, the Internal Revenue Code section 501A says that a variety of different organizations can qualify for tax exemption if they fit into the definitions contained in generally 501C of the Internal Revenue Code. And I believe there are about 29 different subcategories of entities. The main entities under 501C that people get involved with would be a 501c3 entity, which is a charitable educational organization that can be set up again as a corporation, unincorporated association, or a trust, and which can receive deductible dollars from people and use them for charitable and educational purposes. Another subcategory that we usually deal with is a 501c4, which is a civic social welfare organization that is operated for the betterment of the community at large. It doesn't qualify as a C3 because usually it's engaged in a lot of lobbying activity, which is either the lobbying of a legislative body like the Congress, the state legislature, a board of supervisors, a city council, or is engaged in lobbying the citizens when there is a ballot measure involved, and the public is considered the legislature being lobbied to approve or disapprove of a ballot measure, which is the legislation. Another area I'll just mention quickly is 501c5s, which are labor unions, and they get exemption under that category. 501c6s are reserved for trade associations, chambers of commerce, business leagues. Our Hellenic Law Society of California, and before that, the Hellenic Law Society of Northern California got exemption from the IRS as a business league under 501c6, League of Professional Attorneys. Another popular subsection of 501c is a C7, which is a social club. And if you want to collect stamps and join together with other stamp collectors, you can file for 501c7 and obtain tax exempt status. So any money that you raise to promote your stamp collecting activities would not be taxable. Another category that I deal with in political law is 527 of the Internal Revenue Code, which deals with organizations that are primarily formed related to the election, selection, nomination, or appointment of candidates for office, and or presidential electors. And a 527 committee can also form as either a corporation, an unincorporated association, or a trust. So those are the legal forms and the tax status. And now implementing the creation of an organization, there are 4 primary entities that I deal with, public entities: the Secretary of State, the Internal Revenue Service, the Franchise Tax Board, and the Attorney General's Office. I assume you all got the outline that I had prepared. So there's, if you have that, you can see the sort of the basic things.
Peter, can I ask everyone to mute themselves? There's a little bit of feedback. If you're not asking a question, please go to the left bottom and mute yourself. Thank you.
Great, thanks, Peter. So you can, rather than go through the outline specifically at this point, I thought I would just do sort of an example of what we go through when I get a new client, how we set up the nonprofit. So say someone calls me tomorrow and says, I want to set up a charitable entity, 501c3. So I go, great, okay, give me a lot of information. I'll send you a checklist of what I need. I need the name of the organization. I need to know who the directors of it will be. I need to get a statement of its purposes, what its scope of activities are going to be. I need to get a 3-year budget from them, a current year plus 2 additional years. And it can be a guesstimated budget. Doesn't have to be precise. And the organization is not bound by it. It can change the budget anytime it wants to. I will ask them questions like, do you want to be board driven, or do you want to be a membership organization where you have members that pay dues and they elect directors and they basically have ultimate power over some aspects of the corporation, like dissolution. So I go through a checklist, I send it to them, I wait for them to get back to me, and then I say, okay, now we're ready to proceed. And I will get someone who has to be an officer to get on the computer with me when they're at their end. I'm here in my office. We go online and we file for a federal employer ID number from the IRS. That's done electronically on a form SS-4. Takes 10 or 15 minutes if you know what you're doing. It can take an hour if you don't know what you're doing. Like the form doesn't allow general punctuation. So if you put 123 Main Street, comma, suite X, it'll reject it. It won't let it go through because it has a comma. Little things like that can hang you up. We then, if they decide they want to be a corporation for liability purposes, then I can go online. And as Jim mentioned, the Secretary of State's office has forms that you can fill out interactively and submit electronically online and pay the filing fee with the PayGov function. And you can submit it. But as Jim mentioned, the Secretary of State's office is sort of a nightmare. You have to wait a period of time. Right now, I think they're running 3 to 4 weeks behind schedule and reviewing documents for filing. So eventually, within a month, you'll get confirmation back that your articles are okay, or if there's a problem with them, you have to sort of start over and resubmit. There is a link on the Secretary of State's website that will actually tell you what their timing is. I looked at it yesterday for a client and told them they were going to have to wait 3 weeks to get a response back as to whether they're properly incorporated or not. However, once they process your paperwork in 3 weeks or 4 weeks, they will consider it filed as of the date of submission. So if you file it tomorrow, it'll be deemed filed as of tomorrow, even though you don't get approval for a month. So then we've got articles filed, or if they're not going to incorporate, I will prepare articles of association and ask that 2 of their people, 2 of their group, sign it, and they are associating together to form this unincorporated association. And then once we have articles of association or articles of incorporation that a bank will accept, sometimes a bank won't open up an account until they have a certified copy of the articles back from the SOS. But one way or the other, eventually we get a bank account opened with the federal employer ID number and the articles, the organizational document, the articles, one way or the other. And then they can start operating and receive money and set up shop and do whatever they're going to do consistent with their purposes. When you incorporate the Secretary of State's office and you get your articles back, you have to file a statement of information within 60 days afterwards. Jim referred to that even for profit entities. And it's a simple form that basically says, here's our name, here's our address, here's our officers, here's our agent for service of process. And that form gets filed in 60 days. And then you have to file that form and renew it every 2 years in the anniversary month of your incorporation.
Let me just make a comment on that. A couple of years ago, I had a client who had monies due them from the controller. They had escheated. And I discovered, lo and behold, because you know that you can file statements of information electronically. In fact, most of them are. And someone had filed a statement of information for this client, totally fictitious, different address, different officers. And I figured they did it because they were chasing the escheat monies. And they would use a filed statement of information as evidence that they were entitled to the escheat monies. And that, of course, astounded me that one could do that, but they can, and they did. And this filer, turned out, had done that repeatedly.
Wow.
So, yeah, it's sort of, I don't know how one does a tickler, but it's sort of worth somehow. Yeah, isn't that amazing? Literally,
Yeah.
they stole our identity. So, of course, we promptly filed a correct statement of information and now carefully monitor it.
Yeah, I mean, the fraud exists in all different areas, like they keep seeing on television how you can lose your house. You know, someone could do a deed without you even knowing it. So it's a good argument for having LifeLock or whatever it's called. So going back to the filing, the Secretary of State's office does have online forms to file as a corporation for a C3 charity and also for a C6 business league. However, they don't seem to understand the tax differences between C3 and C4 with the IRS. And I found that the 501c3 online form doesn't work for purposes of getting tax exemption from the IRS. So when I file for a C4, civic social welfare organization, I have my own articles that I've been using for years that are tried and true, and I just mail that in to the SOS and wait for that to come back. Yeah, and that's
Can I ask you, Peter, you mentioned, you know, you can have a trust as a, but you're not referring like estate planning trust, right? What kind of trusts are these that can qualify to be a charitable, whatever?
yeah, what I often do, the model I use is to set up a corporation, say for a 501c4 civic social welfare organization that's doing a lot of lobbying, and they may want to do some charitable activities. Contributions to a C4 are not deductible, but I tell them, if you want to set up a separate bank account, so I have the ABC Corporation, a lobbying organization, and then I have the ABC Charitable Trust, and it's just basically a bank account. Well, the directors of the C4 become the trustees of the trust. We create a separate declaration of trust and have them sign it. And they wear two hats: directors of the corporation, trustees of the trust. And they can raise deductible dollars into the C3 account, use it for making charitable contributions or doing charitable activities, funding a school or something like that.
Okay, so you don't need, this declaration of trust is not recorded, it's just there. So
It has to get separate tax exemption. So I was getting into that. So the 501c4 or C3 that I've now set up for the entity, in the weeks that follow, I will put together an application that includes the articles, bylaws, a description of purposes, structure, and activities and programs, fundraising programs, a 3-year budget. And for the IRS especially, there's some forms that have to be included in the packet, a power of attorney form and a user fee form and other things. And I just set this whole packet up, and the IRS has gone to requiring applications for exemption to be filed electronically in the last 2 years for 501c3s and C4s and C6s. So now I put together the whole packet. I scan all of my documents into PDF form. And then when I'm ready to submit the application, I just fill it out, the main application, attach the PDFs, and then submit it electronically for exemption. And we'd have to do the same thing for the charitable trust. Now, a C4 could also just set up a sister corporation for charitable purposes that could be a 501c3 charity. So it's just a question of what legal form you want to follow. And the model that I set out seems to work well for different clients. In filing for exemption with the feds, you use a Form 1023 online for a 501c3 organization. You use a Form 1024A for 501c4 organizations, and use a Form 1024 for 501c6 or other entities that qualify under 501c. The entity then, once I file for exemption, it's going to take quite a while to get that back from the IRS. They're really slow. The COVID, I think, really slowed them down even more. There are similar sections under the Franchise Tax Board contained most in 20 Revenue and Taxation Code section 23701. D is for a charitable entity, E is for a business league, F is for a civic social welfare organization, and R is for a 527 political committee. So you also have to file a Form 3500 with the Franchise Tax Board for exemption. And there are some time limits. If you're a C3 organization, you have to file within 27 months with the IRS. You have to file within a year with the Franchise Tax Board for a charitable status. There's a shortcut. If you file for exemption from the IRS and you actually get the exemption letter, you can file a truncated Form 3500A with the Franchise Tax Board instead of a full application that has all the attachments, and you just fill out a couple pages and send it with the exemption letter from the IRS, and then the Franchise Tax Board will give you exemption also. The other entity I mentioned that comes into play is the Attorney General. If you set up as a charitable entity or a civic social welfare organization that would get 501c3 or C4 status, you have to register with the Attorney General's Division of Charitable Trusts as a public benefit organization, a charity. Even though a C4 may be doing lobbying and promoting ballot measures, that kind of thing, the state considers that to be a public type charity subject to regulation and supervision by the Attorney General's office. So sometimes I get a hybrid situation, like I'm setting up a 501c4 now ballot measure group that is going to focus only on a ballot measure for the next 6 months. After that, they may expand their activities to do local lobbying for ordinances and grassroots lobbying in the city and public education and things like that. So I'm not registering them with the Attorney General's office right now, because organizations like candidate committees and ballot measure committees are exempt from registering with the AG's office. But once they expand their activities, then we will have to register them later with the AG, and they'll have to file annual returns with the AG on a form RRF-1. These organizations also file 990s, some version of a 990, and 990EZ or 990N with the IRS, and a Form 199 or 199N with the Franchise Tax Board. The type of form you file depends on the level of financial activity you have. And if you're a very small organization, you just file an electronic postcard with the IRS and the FTB annually. If you fail to file something 3 years in a row, you lose your tax exempt status.
Are these tricky returns? I mean, or can any decent accountant prepare and file them, or do you know, are these focused on sort of specialists?
Well, my answer, Jen, sort of ties back to what Joe Ramcho, who was a very respected political lawyer that we knew, who died in a helicopter crash years ago, once said about the political laws. He said, this area of the law is a trap for the wary. And I would apply that also to the tax forms. I think you can't run a mom and pop operation anymore in the a political or nonprofit arena. And I would recommend professionalizing it with attorneys and with accountants. If you have a lot of activity and you're engaged in a variety of different activities financially, the forms can be tricky and long. The 990 has a lot of pieces to it. So I don't think it's something that you could just pick up and do very easily. I didn't write any nonprofit books, so I can't claim authorship, and I can't sell my books and sign them for you, but there are, how-to books. There's a whole bunch of them put out by the NOLO Press that contain articles, nonprofit bylaws, a whole bunch of different, steps to follow, that kind of thing. I looked at NOLO stuff many years ago when I was a young lawyer, sort of relied on it a little bit at that time. Then I found that NOLO wasn't satisfactory for my purposes, so I haven't used those at all. And of course, after 45 years of practice, I have my own forms and procedures I follow that are tried and true and work well. So
Yeah, good. That's your next project, Peter. Publish them.
Yeah, I gave up publishing when I wrote my law review comment at
Yeah.
USF Law School in
Okay,
'73.
time to do a second act.
Yeah. I know it's 6 o'clock right now. We started 5 or 10 minutes late, but maybe I should stop real quick for some questions. As I said, this is a primer. There's a whole lot we could talk about more, but this gives you some overview of what's involved with setting up a nonprofit. And generally, also I recommend to people that they, Jim talked about liability and the different legal forms. The corporations code obviously is the strongest entity to create, because it does provide protection to the directors and officers through the corporate shell, as long as they respect corporate formalities, they hold at least one annual meeting, they keep minutes, they act in the corporate capacities, not as individuals. And if they aren't compensated for their services, other than getting reimbursement for expenses, they would enjoy what's known as the good faith statutes of the Nonprofit Corporations Code. which is found in the Corporations Code 5000 at SEC. And I always recommend to people that they get at least a general liability policy of $1 million, which can cost $800, $1,000 a year. And directors and officers, errors and omissions coverage as well, if they are concerned. I mean, typically these nonprofits don't have employees. They don't have heavy contractual obligations. They're just raising money and spending them for a ballot measure or to lobby the local board of supervisors on something, that kind of thing. So the extent of liability is probably low. You know, you have to worry about defamation if they're doing grassroots lobbying with the public and they're talking about people in the city or county. That's where I come into play and tell them legal clearance is important. Run things by me. Don't start bad mouthing people without it being factually based, because truth is a defense to defamation. Basically that's it. Get insurance and then just mind your P's and Q's in whatever form of nonprofit you want to create. Questions? Applause? Throw money?
Yeah, right. Yeah, all of the above. Well, you mentioned the small nonprofits may not have employees, but if they do have employees, you really want insurance to include employment practices coverage, because, you know,
Yeah.
wage and hour, all that else that goes on now in the workplace, just not worth it, because, you know, it's a nonprofit. And you're not getting paid, and, you know, all of a sudden you get sued, and you have personal liability. If it's awful.
Yeah. Yeah, you can get workers' comp coverage for the employees. You have to get a state registration number, like a federal employer ID number at the state level. And the employment practices coverage, I think, comes along as usually part of the package of getting workers' comp. There's an agency I deal with in Sacramento, McClatchy Insurance Brokers, a fellow named Dick Lemon, who I've worked with for years. He's terrific to work with. And I refer clients to him, and he can get insurance for them, usually, most of the time. Sometimes it's a problem.
So the bigger issue that clients always ask me about their status as employees, officers, or directors, and it's broader than just defamation. Any individual, no matter what corporate status they have, if they participate in a tort, especially a willful tort, like fraud, they can't claim a defense that, oh, I was just acting for the corporation, because the key is personal participation. So they're often asking you about it. There is, Peter, I think you alluded to this, there's a special statute for nonprofit officers and directors that gives them more immunity than if they acted in good faith. Is that did I get that right?
Yeah, it's the good faith statutes in the Corporations Code that protect directors who aren't compensated, who attempt to get insurance for their organization, either general liability or E&O coverage, and who always act in good faith.
And the fraud, yeah, all D&O policies have an exclusion for fraud, but that's why you get a supplement or a rider that says, yeah, but that's defined as a final, non-appealable judgment that found the director to have, you know, engaged in common law fraud. So just the allegation isn't sufficient to blow the coverage, because, you know, that's an important.
Well, this is another little interesting issue. If you plead simply fraud and punitive damages, a carrier might very well try to strong arm you and say, we're not going to defend that. But if there's a claim for negligent misrepresentation, then they're going to cover it because the insurance code prohibits insurance carriers from paying for willful misconduct, and they're not allowed to pay punitive damages. So
That's why you have this rider, because, yeah, they may reserve their rights if the allegation is made, but they have to defend you because it's a final, non-appealable judgment.
so we need,
Finding of fraud.
yeah, we need to get Basil Plasteris to give us the talk on insurance coverage, because that's a very, very interesting subject that interrelates with all of this. So
We could do that in conjunction with Gina teaching us about substance abuses or getting drunk under the table.
Yeah, Gina gave a talk when we were at a bar once about substance abuse for lawyers, and none of us seem to forget that. Gina Pappin.
She wants to do it again.
So some of you haven't asked any questions. I'm looking at you, Angelina. I'm looking at you, Rachel. I'm looking at you, Nikki. You got any questions for our esteemed panelists?
Well,
I
I'll
think
jump.
you might be muted, some of you. I don't know if you're muted.
I truly appreciate just the primer. I mean, it's been a long time. I do employment law, and it's been almost 20 years since I took corporations in law school. And so I needed the primer to start my wheels turning, and just the differentiation, the clarification between the corporate entity versus how you file with the IRS. And I appreciate.
So Rachel, I forget, you're in Southern California somewhere. Tell us where
No,
you are.
I grew up in Southern California, but I'm in San Francisco now.
Oh,
Yeah.
that's right. Okay. All
Yeah.
right. Well, Nikki and Angelina are in Southern California. You guys muted, or what, are you going to say something?
I
No.
actually know Nikki. Hi.
I agree with Rachel. I do intellectual property law, so this is like way out of my comfort zone. So that's why I want to do it. Just get some information, because I'm always looking to, like, some, you have clients that sort of need referrals, or want to talk about stuff, and you just want to be able to sort of articulate, say 5 things before you pass them off to someone that knows what they're talking about.
That's good. I set up a C3 for a fellow recently who wants to set up a home in the Philippines for street children that are orphaned and everything. And for the first time, it's actually going to operate out of the country, not just operate here to benefit another country, like raising money to help people in Greece, for example. And I ran into these requirements of the IRS because of terrorism, where they now require you to fill out a special form with a whole bunch of questions about making sure that the money that you raise here is not going to be used by terrorists abroad. So that was a new wrinkle I ran into in the last year or so, year and a half. And it took a little effort. I consulted with another colleague in another law firm about it. He had some familiarity with it, but even he was a little shaky on it. We weren't sure how to answer some of the questions, but I came up with some boilerplate that I can use, I think, in the future.
So now we can give them a round of applause. We're all unmuted. Thank you very much. I'm going to make a final conclusion with a pitch for the Hellenic Law Society. If you haven't paid your dues yet, and I don't know if any of you haven't paid your dues, please go online and pay the dues. They're not a lot, because we've got exciting things coming up this year. We haven't publicly announced it, but we're going to give out the Athenian Award for the first time since before the pandemic started to Lieutenant Governor Eleni Kounalakis. And we're working on a date. It's going to be at a hotel in San Francisco. Sorry, you guys in Southern California. You can come up for a nice weekend if you want. 2, at the end of October, we've been invited to go to Chicago And we've been talking to the people. There's a National Hellenic Museum, which is going to do an event for us. There's a Greek town back there. There's a lot of Greek exhibits at the Chicago Museum of Art. So that will be the last weekend of October. And then,
Peter,
yeah,
can I just add to that, that the reason we're going to Chicago is that Peter and I participated in the first ever international Hellenic lawyers panel with lawyers from Canada and Australia, and also a lawyer from Illinois, who's an officer in the Illinois Hellenic Bar Association. So they're doing their annual gala in October and basically invited us to join. So if we can get a group and go there, we can mix with some of our Hellenic brothers and sisters.
and we're probably going to try to do holiday parties, one in the Bay Area and one in LA. So stay tuned for that. And if